State of Florida in this honorable court.
Okay, we have one. You may be seated. We have one case before the docket today, Weber v. State. Is the appellant ready to proceed?
Glenn Gifford on behalf of Andrew Weber. This is a two-issue appeal to claims of ineffective assistance of counsel. I'm going to focus on the deficiency prong primarily of the Strickland test today, because I think prejudice is probably a bit of an easier lift for us, considering the jury questions in this case and the expert testimony that the accident was unavoidable that prompted the jury questions.
Well, you're not suggesting the jury had to accept the expert testimony, are you?
Sorry, Your Honor?
You're not suggesting the jury had to accept the defense expert testimony, are you?
That the jury had to accept the expert testimony?
You don't. I noticed you sort of seem to argue that, well, there was expert testimony provided by the defense, so that shows it was a close case.
Well, that plus the jury questions during deliberations that were based on the expert testimony.
Okay.
Our view is that does make it a close case. And the fact that the state, unlike the defense, did not put on an incidentally construction expert. I'm also going to focus, at least initially, on point two, the failure to pose an effective legal objection to voluntary intoxication instruction, because I think that's possibly the most fertile ground for discussion, possibly the reason the court granted the oral argument. I'm wrong about that. I'm sure the court will straighten me out. So, giving the voluntary intoxication instruction was error in this case because only general intent crimes were charged. So the jury had no legitimate use for the instruction in this case. Statute section 775.051, enacted in 1999, says voluntary intoxication is not a defense to any offense. Well, it was never a defense to general intent crimes. So it didn't change the law on general intent crimes in the state of Florida. It changed the law only on specific intent crimes. None of those were charged here. As in cases that arose before the 1999 enactment of the statute, there's no reason to tell the jury that voluntary intoxication is not a defense.
Before you go, can you distinguish the argument you're making from the one that counsel made on direct appeal?
Yes, on direct appeal, well, let's go first to the discussion at trial about giving the voluntary intoxication instruction. This was proposed sua sponte by the trial judge. The standard instruction says give only if requested, so that's initially something to note that it was not requested by the state. It was ordered by the trial judge initially. Second, it says give only if appropriate, and appropriate we think means if there are specific intent crimes charged. The argument of trial counsel was that
Not the argument of, I'm sorry, not the argument of trial counsel, but didn't appellate counsel raise this issue as issue 5 on
as preserved
direct
by
appeal?
trial counsel, but in the same way that it was preserved by trial counsel, which was that it should not have been given because it believed the state of the burden of proving the third element of leaving the scene, which is knowledge that injury had occurred or that the defendant should have known that injury occurred. Trial counsel agreed that the instruction was appropriate as to the fourth element, which was a different element, which was willful failure to remain in the scene, willful failure to provide identification information, or to provide assistance to people who were injured. And that's the way the case went forward on direct appeal. That it was error to give it on that issue, on that element. Element 3 agreed it was okay on element 4, and that the judge had departed from his role as a neutral magistrate. And that appeal was affirmed without opinion. Those weren't winning arguments. The winning argument, the argument that should have been made to preserve the issue for appeal, was that leaving the scene of an accident, and DUI manslaughter for that matter, have no specific intent element. That's the reason that the instruction should not have been given. That's the objection that should have been made. Instead, trial counsel conceded that it applied to one of the elements, and it doesn't. specific intent means, in its most blatant example, premeditation, or aggravated battery, intent to bring about a specific harm, great bodily harm. It does not mean any of the elements in leaving the scene, again, or DUI manslaughter for that matter. Element 4 is willful failure. Willful failure is not the same as specific intent, because specific intent means the intent to bring about a specific result. That's not the way our leaving the scene statute is constructed in the state of Florida. It's not like an escape statute.
Would you say that the instruction that was given rises to the level of fundamental error?
No, not arguing, well, we're arguing this ineffective assistance. We're arguing it under the posture of the case that we have now. The fundamental error claim was made in Olwen, the third DCA case that's discussed in the briefs. So it's not a fundamental error claim here, it's an ineffective assistance claim.
Well, right, but when you get to the prejudice part, the question, I'll more generally ask the question, because this relates to some of the other arguments about the comments that the Assistant State Attorney made during closing. What is the difference between fundamental error, which we would look at on a direct appeal when it's not preserved, and the prejudice that we're supposed to be looking for in a post-conviction motion?
If I recall correctly, fundamental error means the error was such that no conviction can be had under any view of the facts. And that's fundamental error. The ineffective assistance prejudice prong means that confidence in the outcome is undermined. That we don't know that we have a reliable result now. So it seems to me that fundamental error is a much higher burden, even as the prejudice prong.
In my understanding from the Supreme Court decisions, U.S. and state Supreme Court decisions, is that the standard is actually higher, more stricter in a post-conviction when we're looking at ineffective assistance of counsel, because now we're presuming that the performance of counsel was reasonable, and so when we go through this whole analysis, my understanding is that it's actually a heavier burden for the defendant.
Well, I think that goes to the deficiency prong, not the
Sure.
prejudice prong.
Sure, but overall, when we're deciding whether, we're asking whether it made a difference, and if you go back and read Strickland, they struggle with this, and like, how do we make these kinds of assessments? As Justice O'Connor goes through this analysis, it sounds to me, it starts to sound a lot like the fundamental error analysis, which the ultimate question being is, do we have some concern about the validity of the outcome when we look at this? I mean, it sounds like the same for fundamental error. And fundamental error says it vitiates the, the foundation of the trial or whatever that means.
I'm glad to hear that, Your Honor, because I thought fundamental error was a higher standard than the prejudice standard under Strickland.
I mean, fundamental error standard requires the court to find, in essence, that no conviction could be obtained, correct? That's my understanding.
That's my recall of that standard as well, Your Honor. I don't think that's the prejudice prong of Strickland.
I mean, the prejudice prong, go ahead, Judge.
No, but see, here's the problem, and Justice Quintero, I forget the name of the case, but Justice Quintero, in an opinion, struggled with this. There's a problem here, is if fundamental error is the higher standard, you don't raise, let's say you don't raise it, and you can't waive a fundamental error argument. You can raise it in a post-conviction motion as well. But then you convert it to a lower standard if you raise an IAC claim. It just seems like there's this tension between, because in this case, with respect to like the jury instruction, and the jury instruction plus the comments from the prosecutor, all that could have been raised as a fundamental error argument by appellate counsel, right?
It could
And
have.
on direct appeal.
I mean,
Minus the thing about the ineffective assistance of counsel, just saying, hey, the comments that the prosecutor made, those were fundamental error. This jury instruction, even though the trial counsel made one argument, and so this other argument was preserved, but it's still fundamental error, he could have made those arguments, right, on direct appeal?
it could have, but our experience is that recently fundamental error has been tougher to argue.
Sure. And so then here we are, and so you make the similar arguments, but then you add the IAC element to it, and suddenly the standard is lower. So wouldn't the incentive be for a lawyer to not make the fundamental error argument on direct appeal so that then the IAC claim can be raised later with a lower standard?
I haven't considered that, Your Honor. You're ahead of me on that. It hasn't been briefed in that way. And no, so I've gone forward here assuming that we're applying the Strickland standard and not that we are
Oh, I think we are. I'm not
raising the Strickland
suggesting anything
standard
else.
to the fundamental error standard.
Yeah, and I'm not suggesting we're not under, I mean, obviously we're under Strickland, but when we have to ask the question about prejudice, and if you go back and read Strickland and what Justice O'Connor describes as prejudice, it sounds like we're asked, or the trial court first, and then us on appeal, because it's a question of law, on the question of prejudice. Did it make a difference in the trial?
How would that
Did
work
it-
here, Your Honor? Because we did have an argument that was preserved. It wasn't the correct argument, it wasn't an effective argument, and yet the argument was made below.
I guess what my colleague is reaching here is, if fundamental error is not raised on direct appeal, is it waived? Now, Judge Tannenbaum's made the comment that she perhaps cannot waive fundamental error. And I know we're a little bit off the typical Strickland path, which is purely a federal claim raised in state court. But be that as it may, would you say, and I think this is very helpful just in terms of kind of a overarching look at this, would you say that the failure of the trial counsel to make the correct argument, which I think you make a very strong argument for that, in fact, is and was fundamental error?
We can look at it that way, Your Honor, and if the court is moving that direction, that's how we can look at it as well. Could any conviction, if the standard is, could any conviction have been obtained without the assistance of the error? That's a tough burden. That is a tough burden. I'm not aware, I'm not up to speed with what you're talking about, but I'm not aware that we are at that with the Strickland or even with an ineffective assistance claim in state court after an evidentiary hearing, which is where we are right now.
Well, back to the prejudice prong as defined by the federal courts that we have to apply under Strickland. So it says that there's a reasonable probability that the result would have been different.
Sufficient to undermine
The
confidence in
confidence.
the outcome.
So your argument is a voluntary intoxication instruction undermines the confidence in the outcome.
It does. It does. That is my argument. And that is because there was no legitimate use for the jury to put it to. There were two parts of the instruction. One is that voluntary intoxication is not a defense to a crime in Florida. Okay, that's fine, except it never was a defense to a general intent crime, and that's what we have here.
I mean,
What is the
here-
jury to do with that?
You know, we did not write on direct appeal, but here you have a case where his blood alcohol level was 4 times the legal limit. So I assume your argument is the most he should have been convicted of, as you said in your brief, is DUI, perhaps. I don't know that you would
Correct.
concede that, but I assume you would. So DUI, what about the evidence about him turning the truck around in a circle and couldn't leave? Was that an attempted flight? Was that argued below?
Well, that's the state's theory, but the alternative view, the defense view, is that the defendant was unaware that he had hit anything but balloons or debris in the road. And you have to remember, this is a man sitting up high in a Ford F-150 truck with the front end ahead of him. The car in front of him, the one that moved to reveal the motor scooter, was a smaller sedan, Grand Prix. And so there is evidence from which a jury could conclude that he was unaware that he had struck anybody, that he had struck a scooter, certainly not that there were people on a scooter. And it's consistent with everything he said from the moment they discovered him near the accident in the shopping center parking lot, all the way through to when he was at the hospital. He never gave any indication that he was aware that he had hit something more than debris or balloons or bags or something in the road. So if you look at the testimony that the truck tried to move afterwards, going a U-turn spin, Yes, he may have been trying to dislodge something under his truck, but there's no indication in the evidence at trial that he knew or that he should have known that he had struck occupied motor scooter, excuse me.
I'm sorry, I didn't ask you if you wanted to reserve time for rebuttal.
Say again?
I did not ask you if you wish to reserve time for rebuttal.
Has that much time passed already, Your Honor? Yes, I would like to.
You have 5 minutes and 16 seconds.
Thank you.
Good morning and good afternoon, and may it please the court. Ben Hoffman for the state. I will also begin with the jury instruction issue, and I would actually like to start with addressing what I would characterize as two different elephants in the room, either of which should lead you to reject this claim. So first, it was appropriate to give the voluntary intoxication instruction because elephant number one is the fact that defense counsel below specifically attempted to argue that Mr. Weber was too drunk to know that he had hit a person and caused an injury or death. And he actually started this during his opening statement. So this is page 30 of the trial transcript, which is in the direct appeal record.
So your argument is invited error?
I'm sorry?
So your argument is if it's error, it's invited error?
Yes, although I'm not even sure it's error, because I think the standard, before I get to what he said, the standard is not this arbitrary distinction between general and specific intent. What the standard is could the jury be led to believe that voluntary intoxication or intoxication is negating an element of the offense? So in this case, defense counsel was explicit just right out of the gate in his opening statement. So he's talking specifically about the leaving the scene counts, and he says, but what's key here is the other evidence that you will hear that Mr. Weber had no idea that he actually hit a scooter and hit some people, perhaps due to intoxication, perhaps due to how quick the scooter appeared in front of him. He had no idea. So he's starting there. And then it even, I think, actually gets even worse during closing statements. So on multiple occasions, what defense counsel does, again, and he's specifically talking about, he actually brings up the voluntary intoxication instruction. He says, you heard but you hear Miss Kane for the first part of the phone call, describe the crash, and then you hear her get very emotional. So obviously she didn't even realize. Again, normal, attentive, sober people didn't even realize. What he's doing is he is benchmarking Mr. Weber to sober people. And throughout the closing statement, on at least 4 or 5 different occasions, as he's talking about different witnesses, specifically about the knowledge element, he is benchmarking Mr. Weber to sober people and effectively trying to argue that if these sober witnesses, these sober firefighters don't know, this sober Miss Kane doesn't know, then how's a drunk person supposed to know? I would actually argue it was highly inappropriate argument. I understand the state didn't object. That's probably why the judge let him make the argument. But certainly, he shouldn't get the benefit of being allowed to make an argument that's not proper under Florida law and then complain that the judge actually instructed the jury correctly that that is not a defense. So our position first is there's no error. And then as to the deficiency prong, there was really, it would have been futile for defense counsel to raise this argument for a couple of reasons. So first, and this is the second elephant in the room, is the trial judge was aware of this argument. So he specifically, I want to make sure I get my record citations right. But during the charge conference, when defense counsel basically says the voluntary intoxication can apply to the 4th element, but not the 3rd element, Judge Hankinson disagrees and says it should apply to the 3rd element, the knew or should have known element, gives a policy reason, and then specifically says, and I'm trying to find the record citation, specifically says that that he is aware of the case law that is held that leaving the scene is a general intent crime instead of a specific intent crime. He openly disagreed with it on the record and said he intends to give the jury instruction anyway. At that point, I'm really not sure what defense counsel is supposed to do in order to preserve it, because the case law says he's not required to engage in futility, to preserve an issue for appeal. But the point of objecting is to put the judge on notice. The judge is obviously on notice. Says he disagrees, he's going to give the instruction anyway. There was nothing, we forget pursuing this as a fundamental error claim. There was nothing to stop them from pursuing this as a preserved error. I don't know why they didn't, but it's not because it wasn't preserved.
What about my question to Mr. Gifford, that, about what they actually have to show for prejudice and sort of comparing or contrasting the fundamental error standard with the prejudice standard in Strickland, and just as here's what I'm looking at, so here's where my question is. So Strickland, at least twice, talks about focusing on, the ultimate focus of the inquiry must be on the fundamental fairness of the proceeding whose result is being challenged. And then talks about whether, despite the strong presumption of reliability, we have to ask whether the result of the particular proceeding is unreliable because of a breakdown in the adversarial process that our system counts on to produce just results. That's Strickland. Makes a reference to fundamental fairness again a little bit later on. And then, the Supreme Court Florida Supreme Court talks about fundamental error from the perspective of something slightly different, but still seems similar. Must reach down into the validity of the trial itself to the extent that a verdict of guilty could not have been obtained without the assistance of the alleged errors. Or an error is deemed fundamental when it goes to the foundation of the case or the merits of the cause of action and is equivalent to a denial of due process. Seems to me that Strickland, as applied, through the 14th Amendment, or the Sixth Amendment applied to the 14th Amendment to these types of proceedings, it's still a question of due process in both instances. So isn't this almost the same inquiry or similar inquiries?
I think they are similar, Your Honor. I was actually, as you were talking with my colleague, I was struggling with the distinction there. The language that I think I used in briefing for it, not that this helps too much, is the prejudice prong requires a showing that but for counsel's deficient performance, it's reasonably probable that the jury would have reached a more favorable verdict. That's Strickland. I'm aware that for the fundamental error language, I'm more familiar with, I think it comes from State versus Delva, the could not have obtained a guilty verdict without the assistance of the alleged error.
Sure.
They
say that, but the Supreme, just as another example, so more recently in FBV State, the Florida Supreme Court, in quoting Hill, a prior decision, they say a reasonable probability is a probability sufficient to undermine confidence in the outcome. So and that's fundamental error. That's their description of fundamental error. So it seems like on both sides, the question is more of a gut check from an appellate court's perspective, ultimately. When we look at this whole thing, do we have some concern about the validity of the outcome? I mean, we can phrase it in a couple of different ways, but they seem similar, and that's what I'm trying to figure out is, so this is an IAC claim, or it's framed as one, but it sounds like it easily could have been made as just a fundamental error argument in the direct appeal. And should there be a lighter standard if you do it as a post-conviction motion as opposed to raising it as a direct appeal?
There shouldn't. I think they could have raised this as a preserved error, but to your Honor's point, the answer would be no. And I guess I'll analogize to, this is more the fundamental error angle, but this court decided a case, Knight versus States. I think it even went en banc for it. But this was the case where the court held that fundamental error in a jury instruction can be waived depending on the circumstances. And part of the rationale was we don't want to incentivize, I think the language was sandbagging, but regardless of what verbiage you use, we don't want to incentivize attorneys to sit on their hands and not pursue claims when they're able to, whether it's a preserved claim, whether it's an unpreserved claim. So from a policy perspective, regardless of which language sounds like it's imposing the stronger standard, just from a policy standpoint, I would agree that defendants should not have an easier time raising an ineffective assistance claim when the claim could have been raised on direct appeal. And again, the jury instruction issue was raised on direct appeal. I understand it was a different argument, but it was actually raised in two different regards, because I know my colleague brought up the give if applicable. That was also brought up on direct appeal, because not only did they raise the argument that it's relieving the state of having to prove burden, they also argued that the judge departed from neutrality, and that went to the fact that he brought it up before the state did, even though it was obvious the state event.
Well, you know, it's interesting going down this line of questioning that my colleague has initiated, because I looked at the direct appeal brief, and the first couple of issues were sufficiency under the old standard of reasonable hypothesis of innocence, of course. Because actually this case is, the original case number in our court was an 18 case number. I believe the crimes occurred in 2017?
I think it was 2016.
So now we're talking 8 years. So 8 years later, we're now debating this trial. And the sufficiency claim kind of dovetails with Strickland, doesn't it? In that, you know, was the evidence insufficient to sustain a conviction? I mean, it's interesting that in the prejudice prong, it's almost as if, is the appellate court supposed to look at it and think, well, he certainly seems guilty, but the proceeding was flawed. So 8 years later, we're going to order a new trial? Because this court looked at sufficiency and rejected those arguments under the more favorable standard to the defense, the reasonable hypothesis of innocence standard. Those issues were raised in terms of causation, et cetera, and those issues were rejected. Is that not accurate?
It is, Your Honor, and I guess just, I guess that dovetails into the comment that the state made during closing argument about the 1%. I don't want to delve too much into it because my colleague didn't, but another elephant in the room is, as I know you had asked about whether the jury had to accept the expert testimony. One of the elephants in the room is, if you look at, I think it's Mr. Stewart, the engineer that testified, if you look at the actual, because he quantified all of this, and obviously we quibbled a little bit below with how he did it, but at the end of the day, he quantified the speed at 45 miles an hour. He quantified Mr. Weber's distance behind.
Right, if the jury had believed his testimony, they would have acquitted.
I'm sorry?
If the jury had accepted his testimony, they would have or should have acquitted, by the way I read it.
Well, that, but I think I might look at it just a little bit differently, Your Honor, in the sense that you actually could accept Mr. Stewart's testimony and find that it's unavoidable because he's following too closely. 45 miles an hour is what he put Mr. Weber and Ms. Kane at. Mr. Weber's 40 feet behind Ms. Kane, according to Mr. Stewart, by averaging the range of distances she gave. He's less than a second behind her. If she decided to hit her brakes all of a sudden, a sober person couldn't avoid her. And he's making the argument that not only is he not under an obligation to not ram into Ms. Kane, he has no obligation to not ram into the person in front of her.
So what do you make of the jury question?
So with regards to the jury question, I understand Judge Hankinson did not directly answer the first question, and I have them here. But I want to make sure I get it right. Can you cause or contribute to an accident that's unavoidable? The answer is actually yes, for two reasons. And again, I understand Judge Hankinson was hesitant to directly answer that with the fear of potentially invading the province of the jury to answer that. But since we're on appeal, we don't have a jury. The answer is yes, for two reasons. So first, as I mentioned, right, taking the expert at face value, Mr. Stewart, he's obviously following too closely. And I'll just kind of remind Your Honors, some of the language that this court used in Mizell, and I know Your Honor authored that opinion, is in order for the decedent's conduct to be a defense to DUI manslaughter, it has to be the sole proximate cause. So even if the crash is unavoidable, One, there's the issue of, is it avoidable if he's not following too closely? But second, there is the question of, even if it is unavoidable, did it have to be a fatal crash? Because the prosecutor even was questioning, I think it was the other expert, Dr. Morgan, would 1 second of hard braking reduce a vehicle speed? And he had to agree with that. So even if it is an unavoidable crash, and even if it is unavoidable because he's not following too closely, we still have the question of, could he have actually mitigated it? Because one person survived the crash. We don't know that another person couldn't survive if he lowered his speed. So that's the first reason.
Isn't that something that, and right, and there is no evidence of when the decedent actually died in the sequence of events. I mean, it could have been on impact, or it could have been when
I think
it caught fire, or...
In all candor, Your Honor, I think there was testimony that it was instant or near instant. I don't recall specifically, but I don't want to say that he didn't die instantly and it turns out he did, because I think there may have been some evidence.
Well, that's what the
that he-
coroner said, that it would have been instantaneous
Okay.
based on the severity of the injuries.
Okay, well, and yeah, so, and I thought it was, instant or close to instant. But the point is,
The
hitting.
focus would be just the speed aspect of it, right? That if he had gone just a little bit slow, if he, in that split second, had broke.
Right,
brakes,
so-
brake just
Hitting
sooner?
a vehicle in front of you at 45 miles an hour is obviously very different than hitting it at, say, 25 or 30 or 20 or whatever, however much braking you can do in a second. Obviously, hitting a vehicle at 45 miles an hour is different. So I realize I kind of went off on a tangent. Now I'm talking about the prosecutor's the 1% comment, which, I argue it's not a misstatement of the law for the reasons that I just said. But as to the jury instruction question, just kind of to reiterate quickly, our position is no error in giving it, and I don't know if I would call it an invited error, because I think the standard for giving the voluntary intoxication instruction is not this arbitrary distinction between specific and general intent crime, because it's not a defense to any
So in
crime.
other words, if the defense raises intoxication, they do so at their own peril.
I guess, which might be another way of saying invited error. I don't know. I don't want to leave the door open to him to then say, on rebuttal that now it's ineffective assistance for inviting it. But
Could Mr. Weber have framed his post-conviction motion as, instead of IAC, just gone right out, it's like, look, talking about the prosecutor's comments to the jury, a few of them were a little bit, sort of beyond what should be accepted for professionally. Could he have made the motion just, look, these comments are so outrageous that it undermines the confidence in the validity of the trial, or it diminish my due process rights in some way, that this trial is just invalid constitutionally and I should get a new trial? Could he have framed it that way?
you're talking
Or
about,
done it
are you
accumulatively? Like, look at the comments from the prosecutor plus this stuff with the jury instruction. So cumulative, like, could he have argued just these underlying errors instead of focusing on whether his lawyer should have done something differently?
I think you're asking about on direct appeal.
No, I'm asking on this post-conviction motion. And just argued that all of it is fundamental error, because the Supreme Court has said that, like, for instance, like, you can, if you don't raise double jeopardy on direct appeal as fundamental error, you can still raise it in a post-conviction motion. You have not waived that. That's what the Florida Supreme Court has said. So along the same lines, could they argue, look, all of these comments are fundamental error. It is a fundamental problem with the trial, and just argued it that way.
I think the way I would frame it, Your Honor, I'm not sure about in post-conviction, because like the double jeopardy example you're giving, typically our post-conviction avenues, there's two. There's the ineffective assistance, and then there's the sentencing aspect under 3.800. I don't know how this would have fit under 3.800. So I think, but to answer your question, I think what they could have done is done the same thing on direct appeal under the fundamental error standard, including under a cumulative error standard. And I think, correct me if I'm wrong, but the comment you're asking about, I think, is it's not open season on mopeds.
Among others, yeah.
Okay, well, I mean, I hope it's not the 1% comment, because
No, not
I
the
don't think it's.
1%,
But right, so like, take for instance the open season
commenting
on.
on the defense's strategy and those kinds of things as well.
Okay, well, I guess to answer your question with at least an example, it's not open season on mopeds. I don't agree, I guess at the outset, that it's a golden rule violation. Obviously, I agree, it should have been sustained for a reason.
And I just want to be clear, so my question's not asking you to comment on the merits of the argument if they made it just as that as opposed to an IAC claim. What I'm trying, still as I was asking initially, trying to understand, so originally ineffective assistance to counsel claims, going way back, they focused on like the lawyer was sleeping during the trial. The lawyer didn't show up to court. The lawyer did all these very obvious bad things that clearly affected the defendant's right to have effective assistance of counsel. Over time, it has morphed into like every trial error can be converted into an IAC claim in some way. And so here we are with these things that appear in the record. They appeared in the record with the direct appeal. Maybe could have been raised as fundamental error arguments on direct appeal. They weren't. And now we have this post-conviction motion. And I'm trying to understand, well, couldn't they be raised as fundamental error here? And if they're framed as an IAC claim as well, does that change the analysis in some way?
I realize I'm a little over time, but if
You
we
may
are.
answer, if you can.
Okay, if we are, I guess the short answer is, if we are talking about this in the post-conviction context, this is just thinking out loud, which I do at my peril, but if offhand, I think you have to fit it into either ineffective assistance or a sentencing error under 3.800.
Right, the goal, so the goal of a post-conviction motion, especially when it's focusing on the judgment of conviction and not the sentence. I'm not talking about a sentencing, like a 3800A kind of error or something like that. Just talking about 3850, we're talking about focus, is the judgment of conviction valid, constitutionally valid and sound? That's the focus now. That's the focus of a post-conviction motion is, were his constitutional rights at that trial, his due process rights, was he deprived of his right to due process in that trial because of a variety of things that they point out? And they seem to be picking around the big errors, these problems potentially with what the prosecutor said, the jury instruction, a couple other things, and dressing it up as an IAC claim. And I just don't understand why. I mean, if the focus is supposed to be on the validity of the trial, why not focus on those as opposed to whether counsel should have made an objection, should have done this, should have not done that? I guess that's ultimately my question.
And the reason I think, the short answer is, the reason that they wrap it up that way is, I think in the post-conviction context, I think they have to. Like, I understand what you're getting at. I don't, off the top of my head, we're either in 3850 or 3800. Outside of those, it's not a cognizable post-conviction issue. So the short answer is, it should be raised on direct appeal as a fundamental error in cumulative error analysis. And I see I'm well over my time. I'll just ask you to affirm on all the issues. Thank you.
Thank you.
First, voluntary intoxication was not a defense at all, just the opposite by trial counsel. There may have been some offhand remark to defendant didn't realize he'd hit a motor scooter, perhaps due to intoxication. Didn't pursue that at all, never pursued that. In fact, in closing argument, made clear intoxication is not a defense, it's not an issue. You judge the defendant the way you judge sober people. And that's the remark in closing argument that counsel was referring to, and that was in the context that voluntary intoxication was not a defense. Argument was made that if the accident was unavoidable, could the defendant still be convicted? Defense experts asserted, testified that for sober people, the accident was not avoidable. And the answer to that is no. If the accident is unavoidable, no, you cannot convict him of a crime that has as an element causing or contributing to the cause of an accident. The legal standard, the jury's not instructed on this, but it's deviation or lack of care. If the accident's unavoidable, there's no deviation or lack of care. There was a statement made that the defendant was obviously following too closely. I don't think there's any evidence in the record to support that. The driver that was ahead of him said that.
But again, isn't that, I mean, this has been a very interesting oral argument, and we appreciate the arguments of both counsels. But it just sounds like we're sitting here hearing a direct appeal, that we're hearing that the evidence was insufficient. And I'm not trying to diminish your rhetoric or argument or logic, but that argument was made on direct appeal. In fact, in two separate issues, that under a reasonable hypothesis of innocence, the defendant could not be convicted. And now, perhaps tagging along with Judge Tannenbaum's questions, here we are, aren't we addressing the very same issue?
We got off on a tack I didn't anticipate, and I'd hoped
I understand
to get
that.
to the ineffectiveness part of this.
But how is a lawyer ineffective, and I don't mean this as an adversarial question at all, but how is a lawyer ineffective when the issue is sufficiency of the evidence? Was it an avoidable accident, or did he contribute at all, I think I said in my cell, our court said, if you could, and that, I think, and I hope we were following Florida Supreme Court precedent, which is very stringent. If you drink and if you're in an accident, you are very likely to be subject to criminal liability at a very low standard of responsibility.
If there is also deviation or lack of care, which one case calls simple negligence. So there's an additional element, and that's the element that we need to look at. That's what the theory of defense turned on. And so, no, the issue is not sufficiency of the evidence. The issue is, was there ineffectiveness that, but for that, the jury might have reached a different verdict. It's a very different issue from sufficiency of the evidence. We're not re-arguing the direct appeal.
Well, let me ask it this way. If the evidence was sufficient to convict him as a matter of law, under Florida Supreme Court precedent and Mizell, how could the lawyer be ineffective?
A lawyer can be ineffective.
How could his performance be prejudicial?
His performance can be prejudicial because he has presented a theory of defense and testimony to support that, but he has made other errors, such as not mounting a reasonable objection, an effective objection to an instruction, not objecting to closing argument remarks, not asking for a curative instruction, when he might have. If a quarterback drives a team down the field to the goal line, misses an open man in the end zone, throws it to the defensive back who runs it back for a touchdown, that lawyer's done a pretty good job until the moment, that quarterback has done a pretty good job until the moment he has not, and he has cost his team the game.
No, unless it's a strategy. Unless it's a strategy move and, you'd rather get the ball to the center of the field and kick a punt to win the game instead
There
of a
was-
pass. Isn't that strategy?
It could be. There's no evidence in the evidentiary hearing that the defense counsel pursued this as a strategy. It was asked, and he said, no, sometimes you do and sometimes you don't. I can't really recall. And he said, when I look back at the arguments that were made, yeah, I should have objected at certain times. And, we didn't get to issue one very much, but the failure to request the curative instruction, it had an effect because the prosecutor, after the objection was sustained, went right back to the well and said, we have mopeds everywhere in Tallahassee. There had been, following the objection sustained, a motion
Would you have been
for curative instruction.
would you have been procedurally barred from just framing the post-conviction motion as that, just focusing on the prosecutor's comments to the jury and without the mention of whether the lawyer was ineffective?
Possibly, but let's remember, this was a pro se pleading. This is a handwritten
Sure.
pro se 3850 motion.
But just conceptually, would you have been procedurally barred? Mind you, those arguments, they were not preserved objections, obviously, because there wasn't an objection made, and the argument wasn't made on direct appeal, and it would have been only a fundamental error argument anyway. So with that context, under the rule, under 3850, would 3850 have barred you from framing your post-conviction motion, or Mr. Weber from framing his post-conviction motion as, look, I was denied due process, this trial is this conviction is invalid
I don't know.
because of the comments that the prosecutor made to the
No,
jury?
I understand what you're asking. I'm sorry, my answer is I don't know if counsel would have been barred by that, because I proceeded, by the way, that Mr. Weber filed his motion pro se, and that's what we've all assumed we were talking about today. The court has looked at it in a different way, and if you'd like some supplemental briefing on that, we can provide that. Just one final
I just
note.
think it just ends up getting us back to the same place. You know, even because I know you want to talk, we didn't let you much talk about the ineffectiveness aspect of it. And I asked some questions focusing on the prejudice side. So, but the point of that is, if it had been framed as just it was fundamental error or deprivation, it deprived me of due process because of these comments, we're still asking the same question at the end of the day. What effect did all of that stuff have on the trial? And when we're looking at this record, do we walk away with the conclusion that there's some doubt as to the validity or some question about it, such that it would justify giving a new trial? Isn't that the same
Yes,
question
Your Honor.
overall?
You can get there either way. You can absolutely get there either way. But I guess the question is, did he do it the wrong way? And is he now barred from doing it the right way? Is that what you're getting at?
No, I mean, I think it's the same question either way, and so the focus ends up not being about what the lawyer did, but about how bad was what the prosecutor did bad enough to justify getting to a new trial, which is what happens when these IAC claims are used
Right.
to dress up these in-trial objection issues, as opposed to, there's a difference between an IAC claim like we have here and one where, well, the lawyer didn't investigate, or the lawyer was asleep at trial, or the lawyer had a conflict of interest. That's a different species of IAC claim than the one that you're asserting.
No, I understand what you're getting at.
And that's what I'm trying to
Right,
parse out.
right.
It's almost like, and this is not necessarily adverse to your arguments today, it's almost as if the prosecutorial comments, which should not have been made, I certainly don't think they should have been made, that in addition to the jury question and the elephant in the room of the sufficiency of the evidence, looking at it as a whole, do we have the authority to say, we're just going to question the whole trial and appeal process here and grant a new trial? You don't object if we go that direction.
I think that's where we're at, except one small quibble, issue is not sufficiency of the evidence. The issue is the effect of these errors on the jury. not
Well, we've
sufficiency.
certainly allowed you plenty of time. Would you like any more? I'll give you 30 seconds to conclude.
There was one mention of,
Or a minute. We've asked you a lot of questions.
there was
No
one
objection
mention
from
of
the state.
someone sitting on their hands. There was no sitting on their hands here. Trial counsel presented an effective defense, didn't carry the ball across the goal line. It was a 5-issue appeal, may have been close to the 50-page limit. Nobody sat on their hands. Attorneys were doing the best that they could under the circumstances, under the rules that they understood them, and particularly Mr. Weber filing his pro se appeal. His pro se motion for post-conviction relief, did the best he could too, understanding the law as he did. If we're talking, I'm not sure I'm getting exactly what the court's getting at, but if we're talking about a new rule, a new requirement, a different requirement, let's apply it prospectively and not to Mr. Weber under these circumstances.
Thank you, counsel. Thank you both. The court's in recess.
All rise.